Hence, we call constitutional custodian is Supreme Court of India. If anything happens in terms of constitution, the question summarily, the question raised, the people approach by questioning the amendment or anything changes in the constitution, the people will approach to the court in order to referring a constitutional violation or constitutional breach. If anything ultra vires in the constitution, finally that I wanted to say, if anything goes wrong in the constitutional basic structure or constitutional violation, it's a responsibility of the court that protect the every line of the constitution without any hesitation. Hence, the Court of India is also called as a custodian of Indian Constitution. Then because of that, the every case since 1950, if you could see, the court will give a complete and judgment and a verdict in order to protections of the Constitution of India, isn't it? Now, I just wanted to tell you here is that on what is the Indira Sahani and other verses of Union of India with respect to this and case of BC and reservation. In this one, the Supreme Court, and she questioned that along with others in the 1992 16th November, giving reservations to backward classes which is called BCs is right or wrong. And in this Supreme Court have given it is valid. Giving reservations to backward classes as per the constitution, truly it is considered as a valid, that you need to understand. The second one is that I am not going to speak a much history about Indira Sahani versus Union of India because I just wanted to link it, the thing which are related to this. That's why just I am trying to brief it about this case. Then after that, they mentioned that on the grounds of caste, 50% reservation should not cross. Under the verdict of Indira Sahani in the 1992, giving reservations to this 27% of quota of reservations to BCs are considerably is right and it is been valid. It is a valid. And the second one is that caste wise in the future, if government plans or people raised a demands in order to claiming the reservation, that it should not cross more than a 50% of quota. It was a cap, it was ceiling. The Supreme Court of India has kept a ceiling, a cap in order to promoting a reservation further in the future after 1992. And you know that the 50%, if you could see so far by now, the reservations are been claiming in India by SCs. If you could see, it was nearly, if you see that SCs are been getting some amount of reservation. SCs, STs are getting 7.5 and BCs are having 27% of reservation. Altogether, and if you could calculate it and what is the percentage of this, if you see, take it as a 15. So, altogether 49.5% of the reservation only that we have means 5 and 250 is a 49.5% of the reservation so far we have. But added to this 10%, how much it become 59.5% of the reservation. Hence, the question raised here is that giving reservations more than 50%, truly it been considered as a violation, isn't it? What the Indira Sahani case says that, giving reservations to the BCs and valid and caste and based reservation shall not be increased more than 50%, isn't it? So, as here the 50% is the ceiling which was kept under the verdict of 1992 Indira Sahani versus Union of India case. And also there was a creamy layer, a system introduced. I think everybody knows that. Creamy layer, also it's a part of this verdict. Do you understand my point in the further? Even the creamy layer also has been added to that. A family income, and initially it was more than 5 lakhs and soon after it been increased a cap 8 lakhs, then after more than, if you could see that. And however, we shall have another class on this and creamy layer and what was the reason that and which committee has given a report to and capping and defining about this and creamy layer and all other thing. But the one thing that you need to understand in this court a verdict it was that, and it promoted giving reservation 27% to the BCs was invalid. And the caste based reservation shall not increase to more than 50%, that you need to understand, isn't it? So this, how do we link this 1992 Indira Sahani and others versus Union of India case to this and EWS reservations? That is a very, very important that you need to understand that. Let me tell you here is that, and what is the link here? The link is that, the controversy has come into the limelight. The first one is that, I said that reservation should not cross 49.5%, which means it is under the 50% of the court verdict. There shall be a no and thing entertained in order to providing the reservation more than 50%. But the first controversy have affected to this area, EWS reservation, that it crossing 50%, which means how much it become? 59.5% of reservations have been increased, which means it increases is around of 10%. Giving reservations more than a 10%, it becomes violation. The people are questioning that. Even that in the 20 and based on this in 2019 EWS reservation, there is a bill filed by a NGO organization, non-governmental organization, and people of India, that the first thing is that giving reservation more than 50%, it shall be treated as constitutional fraud or constitutional breach, because it is whenever the constitutional breach and constitutional violation happens, that it shall also, we will define that violation of basic structure doctrine. Violation of basic structure doctrine. I think everybody knows that what is basic structure doctrine. I just wanted to give you a tiny briefing about this and what is a basic structure. I think everybody knows that you reminded 1973 April 24th verdict of Supreme Court. That was the verdict name. The verdict, it has come Keshavananda Bharati case. Keshavananda Bharati versus Union of India case. Versus Union of India case. This truly is a saint, but it made it everybody to think further. We call this a saint, but it is truly saint that he knows every part of the constitution. Behalf of Keshavananda Bharati, 1973, Nani Falkiwala has taken prosecution of this particular violation in the Kerala by questioning the 1963 Land Reforms Act. Not only the case which have confined to the matters of fundamental rights, but it was also become a new facets of Indian Constitution, that in the 1973, the Supreme Court of India have talked about basic structure. Even anything which was related to the constitutional matter in the beginning, whatever the provisions was there in the beginning, since in 1950, after enacted the constitution by the Constituent Assembly, what we have after November 1949 later, since 1950, all provisions shall be treated under basic structure doctrine. Okay, shall be treated basic structure doctrine. So as it has been mentioned clearly that it has given according to the article 15, article 16th article. Now the EWS have made it an amendment. 103 constitutional amendment have made it amended to 15th article, and article 16 is inserted class 6 in the 15th article. In the article 16 even they have inserted 6th subclass. So what does it mean? Anything which shall be and modified the structure or a provision of the constitution without any proper cause, that it shall be treated as a basic structure doctrine. And this basic structure doctrine says that the parliament has every right to amend the constitution, but it should not erode the basic provisions of the constitution. You can do any amendment in the respective of welfare of the country, in respective of protection of the people, in respective of protection of citizens of India. One can understand and the parliament can do any amendment, but it should not suppose to breach the basic provision that has mentioned in the day one of the Constitution of India. Because in the 15th article, the 16th article, it's been violated, that it shall be treated, comes under the violation of the basic structure doctrine. Hence, the NGO have questioned that without any scienticity, without any proper measures, the 103 constitutional amendment has done the breach and the violation in the fundamental right area in order to providing the reservations to the economically weaker sections. Then the first question raised to the facets of the court that it is a violation according to basic structure doctrine. The first question which I have raised in the NGO is that giving reservations that an economically, by inserting the new clause of article in the fundamental right area, that is a 15th article in the 16th article, that it shall be treated as a violation of the basic structure doctrine. Do you understand my point there? However, I said it that, and what was actually the case on the Bharati case says that, and it is defined, it is quoted that there shall be a basic structure doctrine. Whatever the things comes under the purview of the basic structure, I mean the day one provisions in the Constitution of India, that it shall be a part and parcel of the basic structure. So which means fundamental rights area or DPSP area and all the areas which is to be a part of the Constitution of India, that it shall be treated under the basic structure doctrine. Hence, the basic structure doctrine, the parliament cannot amend it, this area. Can amend it, but it should not supposed to breach the spirit of the basic structure doctrine, but EWS and providing the EWS reservations to the people and the 103 Constitutional Amendment Act, that it is eroding the spirit of the Constitution of India because it has done an amendment in the 15 class 6 and 16 subclass 6. Hence, it been questioned by the NGOs. The second question which raised that, can a parliament allow to give reservation on the grounds of economy? The second questions have raised that. So far by now, we didn't have any event that the government or else the Constitution didn't have the thing which is provided, which shall be provided reservation even for the economically backward classes. We have mentioned socially backward. We have also mentioned that economically backward, educationally backward. But we did not seen anywhere in the corner of the Constitution or epicenter of the Constitution that you cannot find out anything that it can be given a reservation to this economically. So this was an area that it been and dragged the 103 Constitutional Amendment in the periphery of controversy. Do you understand my point there? Now, these are all the grievances which have questioned in the court recently. Then soon after, the court have responded to this and all the petitions, the public interest litigation. There have been formulated a constitutional bench by ransacking of this 103 Constitutional Amendment. I am using the word that was used by Dr. B.R. Ambedkar when he was taking a certain provision and deriving the certain provision from the other constitution. The most of the people have said that Dr. B.R. Ambedkar did not do scientific work, but he just copy pasted from the other constitution or kept it and all the provision in the Indian constitution. Hence, it becomes a elephantine constitution, bulkiest constitution, largest constitution, lengthiest constitution. All these names was there. But in the Constituent Assembly, he has used the day which he is addressing to the people, that in talking about and all these provisions, he has used the word, I did ransacking of this all other constitution. Then I have been and derived the provision to the Indian constitution. The word itself, ransacking, is a great that I am using. the court has taken a step to ransacking of the 103 constitutional amendment, that in whether it is right or wrong by giving a reservations to the people. So the thing is that then here the 5 judge bench, constitutional bench it is. 5 judges bench have formulated under the Supreme Court of India in order to verify, in order to checks and balances of the 103 Constitutional Amendment Act. And it has taken in questions to that. And what are this thing it has taken? It has taken that, can a parliament allowed to provide a reservation economically? The first thing, can government has a right to provide a reservations on the grounds and criteria of economically weaker section? The first questions which have been taken under the 5 judges bench in order to verify, in order to and go for investigation. The second thing that, and the second question which have taken into the consideration by the 5 judges bench, it was, can a government allow to provide a reservation even for private institutions? Institutions, isn't it? The two things which have considering, which have taken into the consideration, because I am just in briefing you, and further you can read and very and in-depthly, then you can understand that even other things also there being a part of, and this 5 judges bench. The first one is an economically, can a government, the parliament can do economically reservations to the people or not? The first question. The second one, can a state and can parliament allow to provide a reservation even for private institutions? Because there was also the one questions which have raised from the people of India that, how can the government provide reservations to the public and private institution, not public, private institution? Already 19 subclass G article says that in the fundamental right, a citizen of India can practice profession, can practice a profession or business or anything, what he wishes to do it in the process of earning money. He can establish a college. He can establish, a business. While he is practicing all these activities as in the college and somewhere, he may provide the reservation or not. That is his wish. It's not the wish of the government. Say for example, I am an entrepreneur. If I started any business, it's my wish to provide a reservation to the private. Even being as a private person, I mean to say that in citizen of India, I can entertain the reservation policy and I cannot also entertain the reservation policy. I may follow, I may not follow. It does not mean that it's not something enforceable to me behalf of the government. I should follow the reservation even in my institution. It's my wish. There is some that it been strengthened in the article 19.1 subclass G says that a man has an authority to a person has an authority in his business to provide reservations to the people or may not provide the reservations to them. But there is no point of reason to intervening of the government in the matter of the private business, private occupation. Do you understand my point there? That is also has been questioned, because as per the EWS reservation that has clearly mentions that even the public-private opportunities can be claimed by the EWCs. Economically weaker sections people can claim even in the private institution. That is being questioned to that. Once if it is being claimed that under the EWC, that it means that violation of the fundamental right that it's been strengthened in the 19 class G, 1G subclass. So there is also one questions which have taken by the Supreme Court of India. It did not take it anything which is related to crossing of the 50% of the reservation, all or not. That is an out of the boundary of the court right now. It's all are been attracting the people to discuss something that the person knows about a reservation, do not know anything, then who speaks about and should not cross, it should be below than 50%, all of that the criteria. But the 50% of the criteria which have been given in the Indira Sahani versus Union of India case, that it's not been taken into the considerations of this 5 judges bench, that you need to remember one thing. But of course, there is also then, the nature of the discussion shall also be discussed about a 50% of the reservation, but that was not a primary thing that comes under the discussions of the 5 judges bench, constitutional bench. That is one thing. So this is the stand of the court. I said the stand of the court has taken to verify the 103 constitutional amendment on all of them. But what is the stand of the government? One another side, you need to understand that one thing, that what is the stand of the, I said that if you could cut into the pieces, the first thing, the government has done 103 constitutional amendment, the first part. The second part is that giving reservation under this 103 constitutional amendment to economically weaker section that have questioned by people of India, isn't it? Then what was an stance of the NGOs and the people? I have said it because of while I'm referring the case of Indira Sahani and even in the Keshav and the Bharati, and I have told you many things which is related to the private stand, citizenship stand on the EWS. After all this a controversy, the ultimate authority of the court to have a stand on it. What is the stance of the Supreme Court and providing reservations to EWS? That I have told you, it has taken in 3 or 4 questions and very comprehensively in order to understand and in order to to verify or to ransacking the 103 constitutional amendment, all of them then and 5 judges bench have formulated. Then now the ball is in the court of Supreme Court. The ball is not in our court. Okay. So we have to wait and see the judgment of the Supreme Court of India after this 5 benches judge. We have to see whether it is a right or wrong. All I have said it. So at the same time, we need to also that, and when the government has made it an amendment under the parliament, in the Parliament of India, that they must have a great and thinking and thoughts to providing a reservation. It does not make a sense that easily the government can commit the mistakes and easily can government amend the constitution. It's not like something that there should be some scientificity behalf of the government. What is the stand of the government that I just wanted to discuss with you? The first one is that, I'll tell you one thing is that, and everybody knows that preamble. Okay. I think the preamble and is a word which tells the mindset of makers of the constitution, isn't it? The preamble itself, the half-page paragraph or a half-page that it has written, but it has a comprehensive understanding. The nature of the constitution lies in the half-page of the constitution. Let me tell you what is, and government is preferring preamble. It has objectives. Do you understand? And it tells the nature of the government. It tells the roles and responsibilities of individual. That's the reason preamble, I am trying to linking that and how the giving reservation economically weaker section in relation to preamble, how it is right. It is a stand of the government. The stands of the government, and if you could see, the first one they are referring giving reservation economically weaker sections. Giving reservations to economically weaker section is absolutely correct. And how they have referred the preamble. In the preamble, we have something objectives and we have something philosophical subjects. As a part of that, a government has a responsibility to empower educationally, economically, socially. If you see the preamble, we the people of India, right from that, for the end letter of the preamble, you see the economical and economic word. Which means the government isn't saying that in the preamble, we have mentioned that it is a responsibility of the government to provide an assistance to economically weaker section in order to appease them, uplift them. The government has to take the responsibility in order to fulfilling the objective of the preamble. That is an economic objective. Hence, the government have provided reservations to weaker sections on the grounds of economy, on the grounds of income is absolutely correct as per this government in order to empowering the objectives and the philosophical and legal luminaries of the preamble of the constitution. I think everybody knows that, and the many judgment have come preamble. On the final judgment, if you see the preamble is a part of constitution. Preamble is a part of the constitution, isn't it? So which means indirectly the most of the people who speaks that giving reservations to economically weaker sections shall be treated as a constitutional fraud. And the government is taking a stance is giving reservation on the grounds of, economically weaker section as per the preamble is correct. So government is taking a stand the way what you have done. The act which was done by the government, it is truly correct and valid, that it comes under the periphery of the constitution, they said it. Because preamble, as per the preamble, giving reservation economically in order to uplifting the and economically weaker sections in order to providing the reservation. That was an act which was committed by the government of India, the parliament, in order to uplifting the and sections of income wise weaker sections. That is an economically weaker sections is truly is considered as an correct, isn't it? So I think everybody knows that preamble is a horoscope of a constitution. The one word which have said it by many of legal luminaries in the Constituent Assembly. Horoscope of the constitutions, we say. It is a key to understand the mindset of the makers of the constitutions, we say, and it gives a chance and opportunity to us to understand the reflection of dreams and aspirations of the people of the country. So as is a responsibility of the country to understand the preamble completely, hence the government of India giving reservation on the grounds of economic or income, it is correct, the first stand. The second is that if you could see 46th an article of the DPSP, the 46th article, if you take it out, that in the 46th an article in the constitution, that it says that it is the responsibility of the government to fulfill the demands of economically weaker sections of the society, where government can provide an opportunities in the public, in the sphere of public employment, in others so, isn't it? So it's a government has a complete responsibility to providing an upliftment to the economically weaker sections in order to providing the opportunities in a different sectors. That has and written clearly, explicitly in the constitution of and in the article 46, that is lays in the DPSP. You may ask that, and whenever anything the DPSP, that does not mean that it is an enforceable, because all the DPSPs are not enforceable. But you have to, I just wanted to remind you that in the 1980 case, Minerva Mills case, in the 1980, the Minerva Mills case, that was the Supreme Court have given a verdict that DPSPs and fundamental rights are bedrock of the constitution. You cannot say the DPSPs are not enforceable, non-justiciable. They are the justiciable when it comes to the point of violation. So as the government has taken granted and to understand the 46th article perfectly, and with the legal luminaries, they understood perfectly the spirit of the constitutional article 46. According to the 46th article in the DPSP, it's a responsibility of the government to providing reservations to the economically weaker sections of the society in India. That you need to understand why I am asserting, why I am and confessing the word economically means, finally, the government is granted that giving reservation economically to be considered as a right and valid, that it shall comes under the spirit of the constitution. There is nothing to call, there is nothing to say, it's all our constitutional fraud, our constitutional breach, our constitutional ultra-wide, such kind of the words will not be taken care. Hence, after having the legal luminaries on this, and in the 2019, the government of India have provided reservations to the and economically weaker sections. Finally, the government is granting themselves, it is right. Giving reservations to and economically weaker sections shall be treated as a right action of the government. There is nothing wrong that it shall not be treated as a constitutional fraud or constitutional, that it cannot and defines as a basic structure violation. This is all about, I would like to give you the complete an idea of the 103 constitutional amendment. So once again, I just wanted to, tell you that the 103 constitutional amendment, it was done in the 2019 by the government of India. This is exclusively providing a 10% of quota of reservations to the economically weaker sections of the society, and it has inserted an article in the constitution, that is in the area of fundamental rights, 15 Article Class 6, 16 Article Class 6. And it is provided reservation truly to the economically weaker sections. Now and onwards, they can claim in the public and private institutions, as well as also, and they can be empowered, they can be questioned in the court as per this 103 Constitutional Amendment Act. And the people who do not claim under this EWS reservations is that already those who are existing beneficiaries in the different areas of the reservations like SC, ST, BC are truly excluded from this reservations. Okay, EWS reservation. So today I just spoke about an EWS by taking an considerations of the few of the cases which have been defined, which I would like to and ask you to read and some more, and the data about particular cases. The first one, Keshananda Bharati versus Union of India, that is 1973 in the month of April 24th, that the court have given a verdict about and related to this and basic structure doctrine. I took it a reference of that. And the second reference, I took it a case that was Indira Sahani versus Union of India case that was happened 16th November 1992. And she questioned the giving reservations to the BCs, and the point of that, and the court has given a verdict ultimately. You have to read about it. The second case which I have referred in this lecture. The third case which I have referred, Minerva Mills case, that was happened in the year of 1980, and the court verdict have given, that was a statement, DPSP's directive principles of the state policy, fundamental rights both are bedrock of the constitution. There is nothing to say that in DPSPs are not enforceable, non-justiciable. Okay, all this thing, and you should have to refer it. So that is how you have to link it at the one topic which is insight in the constitution. That is how you can understand. But however, I am not going to speak as something which is related to the controversy area. There are a lot of things the people says there is giving reservation, EWS quota reservation, it entertain mediocrity. Okay, it is an entertaining a mediocrity, and also it is bringing a kind of demands from the people who were asking since day one about in giving a reservation, and entertaining a more reservation that it shall be a panacea for the future for India. Okay, so there may be a chances to happen 100% of reservation. Okay, so however, after all, these are all a kind of pros and cons will be there, but everything which consists of the pros and cons. But this is all about which I have explained to you. I just took it as a verdict and many of verdict as well as to that, and I just given a lecture on this 103 Constitutional Amendment. Thank you so much. Hope you understand. So this is Kanishka Educational Academy, which is providing a lot of online series lectures to you. You can claim it, and that is available in the YouTube as well as to the app exclusively. You can also download the app through the Google Play Store. You can access it, and there will be a free videos as well as to the subscribed videos. With the lesser prices, you can also subscribe it. Thank you so much for listening this lecture, and you can also quote it, and you can also send the questions through the YouTube if you have any kind of doubts and hesitations on that. Thank you so much. Thank you so much to everyone to listen this lecture.